Ladies and gentlemen, please welcome back to the stage, Cindy Chin.
What do you think about this? Thank you, OTCXN, for the candy bar out there. That was really awesome. It's International Women's Day, and my daughter is really going to be so super stoked tomorrow morning when I come home with this. So I thank you, and a shout out to all the ladies out there. International Women's Day, what? Okay, our next guest is Andrew Lom. He's partner at Norton, Rose, Fulbright, and the United States co-head of Asset and Wealth Management in International Business Group. Andrew is the chair of the Bar Association's Family Office Subcommittee. And Andrew, we're ready for you.
All right, hi everyone. It's good to be here. Thanks for having me. So today we're going to talk about initial coin offerings, and they can flip through to the next one. That's good. So what's an initial coin offering, and why might you do one? There's really two main reasons. The main one is raising money. Most of the initial coin offerings that have happened recently have been about raising money. It could also be about getting your tokens or your coins into the hands of people who want them. You don't necessarily have to actually raise money to distribute tokens. So whatever your purpose is, the big question that everyone's asking these days is that a security? If it is, there's a lot of regulation that goes along with that. If it's not, that's nice. It may also be regulated in other ways, so we'll talk a little bit about that. And then once you've deployed your tokens, people will usually want to trade them. That's usually why you get them out in the hands of users. And then there's a little bit at the end. We'll talk about regulatory enforcement in the 15 minutes we have here. So is it a security or not? So usually it's not equity. Usually it's not debt. Those are the two traditional securities that we have. But then there's also something called an investment contract. And so an investment contract, there's a Supreme Court case, it's been around a long time, called the Howey test. And an investment contract is an investment of money in a common enterprise with the expectation of profit from the efforts of others. So there's 4 parts, and you have to satisfy all 4 parts, and then you're a security. So if you break that down a little bit, there's an investment of money. Well, that could be dollars, that could be Bitcoin, that could in some circumstances be your own time and effort, particularly if other people are putting in money. So that's part 1. Then part 2, a common enterprise. And really all that takes is people coming together and doing something together where there's more than one person. So with the expectation of profit, that could be the project is expected to generate revenue. That could be the tokens themselves are expected to go up in value. That could be, in some circumstances, flipped upside down. And it could actually be there's a risk of loss. And so there's a line of cases that come from country clubs, where typically if you are a member of a country club, that's not a security. You pay in some money, you pay some annual fees, you get to play on the golf course, it's all fun. But then there were these developers who said, okay, why don't you prepay for your golf club membership, and we'll take your money and we'll build the golf club. But that didn't necessarily go well, and so sometimes people put in the money and the country club was never built. So they never got to play golf. And there's some series of cases and SEC guidance that says, well, that's a security. That's an investment to build the country club that you then get to play at. And so if there's this risk of loss, it's a security. So expectation of profit, or in some cases, a risk of loss. And then through the effort of others. So people have to do things. There's some literature out there in the token and coin space that says, well, if you're putting in some effort, then that's your effort. And your profit is because you have your effort. Well, that's nice. But if you're putting in effort and you're putting in effort and you in the back are putting in effort, that's still, at least in part, from the efforts of others. So it's not that hard for something to be a security. And if it's a security, that's actually not necessarily a bad thing. Because if it's not a security, you have to wonder, well, what else is it? And some of the other things could actually be worse. So there's the securities law regulatory considerations. Another thing that comes up that people at the SEC have said recently in this context is you go through the Howey test, and that's great. That's what the Supreme Court says is an investment contract. But then you also have to look at the use of proceeds. So, people talk about security coins and utility tokens and other kinds of things. Well, and they say if it has utility, then it's not a security. That's not an investment, right? It does something. Well, that's nice. In the US, that's not in the law. So what does that mean that it's a utility token? So what people are trying to do there is take aim at one of the 4 parts of the Howey test, or several of those 4 parts, and say that it has utility, so it's not an expectation of profits because you have the token because you want to use it for some purpose and do something with it, and that's not just profits. Well, that's fine. But it doesn't necessarily matter what you're using it for. It matters what the whole community is using it for, and also what the token issuer or the project is using it for. So if you're raising money through an issuance of tokens or an ICO, and the money is going to be spent to actually make those tokens or coins do whatever it is they're supposed to do, then you've got speculation and risk of loss under the Howey test. And you may have utility someday, but you don't have utility now. And so there's this intervening period that for some projects could be a year or more where you're doing a pre-sale of the tokens, or you're saying, you pay me the money now, I'll use that money, I'll build out the tokens, and once they're ready, then I'm going to distribute them to everyone. In some models, that looks an awful lot like a forward contract. People also use something called a SAFT. It's a simple agreement for future tokens, modeled off of the simple agreement for future equity. And in a SAFT, you're doing exactly that. You're putting in the money, and someone is saying, OK, I'm going to take that money and build the tokens, and when I'm done, I'm going to issue them to you. So I think most people now, and 6 months ago it may have been different, but most people now will look at the SAFT and say that probably is a security. And just because the SAFT is a security doesn't necessarily mean that the token is a security. So what some people are doing is they're doing their SAFT now. They're treating that as a security. They're using Reg D. They're using Reg S. So Reg D is an offering to accredited investors. Reg S is an offering outside the US. There are other things. You could do a full-on registration statement with the SEC. There are different kinds of crowdfunding that might work. But so you're treating your SAFT as a security. And to some degree, you're punting on the question of whether your token is a security because it doesn't exist yet, doesn't trade yet, doesn't do anything yet. So maybe you don't need to answer that question yet. And in a year from now, once you've built it, maybe there will be some regulations that may be helpful. Or maybe not. So you put in risk factors in your SAFT that all these things could go wrong. And that, to some degree, protects you when you're doing the offering. So all of that, we're talking about the initial coin offering. So the primary sale of the tokens in that creation event. But really, most tokens, the point is that they trade. And so maybe the SAFT is a security, it probably is. Maybe the token is a security, maybe it's not. But so once things start trading, well, gee, what if the token is a security? Right? Securities aren't supposed to trade publicly except in regulated markets. So maybe there's a way to set up a sandboxed market of accredited investors so that that's who trades the tokens on some kind of a private exchange. Well, that might work, but that's not really the point. That doesn't give you a large enough audience. So recently, yesterday, the last couple days, the CFTC and the SEC have made a lot of noise about exchanges. So the risk, if the token's a security, if it's trading on an exchange, the exchange is not registered as a broker-dealer or as an exchange or as anything else, then that exchange is in trouble because they're facilitating trades in securities. The securities haven't been registered anywhere. The tokens haven't been registered anywhere. So that initial group that you sold to in your initial coin offering now has a problem because they want to resell securities that aren't registered either. So the whole thing kind of sort of starts to jam up, which is why there's such interest in utility coins, in trying to find ways that the tokens aren't securities, because it really affects the liquidity, not necessarily in the issuance, but in that secondary market trading. So all of that, though, is still worried about securities. So if it's not a security, that's great, you don't have the SEC. But some of the things that you do to make it look less like a security may push it to look more like a commodity. And at the end of the day, most things are commodities. And we don't think of them as commodities because, generally speaking, commodities aren't regulated in the spot market, right? So, if I want to go into a grocery store and buy a tomato, that's not regulated, at least not by the CFTC, that particular piece of the transaction. Forwards also are generally not regulated by the CFTC. So to the extent the SAFT is a forward, that's okay. That's like the one freebie that we get. But futures on commodities, options on commodities, those are regulated. And it's different from securities regulation, but a lot of it feels the same. A lot of the same concepts pop up, avoiding conflicts of interest, fraud, things like that. And the CFTC does have jurisdiction to go and pursue fraud in the spot markets. So even if you're just doing a commodity token that's in the spot market, that doesn't necessarily get you out of the woods. And then we have a federal system. So there's 50 states and a bunch of territories and the District of Columbia. They all have general consumer protection regulatory powers. So if you're selling that tomato in the grocery store, right, there's a state or local consumer protection bureau that you can complain to if the tomato looks pretty on the outside, but it's all rotten and gross on the inside, right? Then there are other features that tokens might have. So people like to talk to them about it's a store of value. Well, an Amazon gift card is a store of value. That's regulated by all 50 state consumer protection bureaus if they choose to. The FTC has things to say about gift cards. So as you tick down the list, just because it's not a security, I said there may be things worse out there. I would rather deal with the SEC and have some federally preempted security than have to worry about the federal government and all 50 states most of the time. And I guess the last piece in the minute and a half that we have left is anti-money laundering. And so FinCEN, which is the Treasury Department group that regulates money laundering, has come out very recently saying that basically token exchanges are money transfer businesses. And so there's a lot of regulation that goes on there. Just because a regulator says something doesn't necessarily mean it's the law. So when you look at, so I guess we can end on a happy note, maybe. So when you look at statements by FinCEN, when you look at statements by the CFTC or the SEC, it definitely indicates a direction that they're going. You maybe don't want to be the person to fight that direction. right? But just because they say it doesn't make it the law, and there is a process that has to be followed. And so there's a direction that's out there. There's enforcement that's probably coming. And you can see a little bit now already, there have been a number of enforcement actions on the CFTC side and the SEC side against what I would call traditional fraud. And there will surely be more of those. But then, you know, there is a timeline for enforcement. It doesn't happen right away. They've got to do an investigation, and you know, maybe there's policy considerations. So some of that may be coming. More rules may be coming. And so this is a very dynamic kind of space. And so we've got a set of rules. We've got the Howey test that we have to play by. You know, and so there are certainly things that you don't want to do. But then there's a lot of fun stuff that we get to think about, and as lawyers we get to think about with clients all the time of what might be a good way of doing this that isn't clearly against the rules, and you know, try to learn something and maybe try to even move the regulations as they get developed and influence that process. So thank you very much. It was great talking to you all, and I think that's it.